Now let us consider some cases where the principle of neutrality and respect for pluralism are applicable. And these cases are based on the findings of our monitoring report on the right to freedom of religion or belief. The Norwegian Helsinki Committee Freedom of Belief Initiative project systematically monitors the developments on religious freedom in Turkey. I have some copies in the back of this report. It's available both in Turkish and English, and on our website as well. We have found that in addition to not protecting the right to freedom of religion or belief fully, that means with all of its components, Turkey struggles to comply with the principle of neutrality and obligation to ensure pluralism. And these shortcomings have implications on two different spheres. One, the freedom of religion or belief, and the second one, the role of the state as a facilitator of religious practices and provider of religious public services. Flaws in the observance of the principle of neutrality directly impact the protection of religious freedom. As mentioned earlier, states are required to be neutral in all their transactions and practices regarding religion or belief. Decisions by the state based on the views of certain religious authority as to which beliefs or manifestations of them are legitimate are also incompatible with the principle of neutrality. Despite this, public authorities in Turkey, including the judiciary, have decided that the Alevi gem houses are not considered as places of worship. The Baha'i faith or Jehovah's Witnesses do not constitute religions, and conscientious objection to military service is not accepted as a manifestation of religion or belief. The fact that the point of view of the Directorate of Religious Affairs has been taken into account in all these decisions casts serious doubt on Turkey's compliance with the obligation to observe the principle of neutrality. Neutrality and pluralism are highly relevant for the effective protection of the right to establish places of worship as well. Until 2003, the term place of worship did not exist in our public works law. The term mosque was used. This meant that until then it was not possible to establish a new place of worship other than a mosque or a masjid. Along with the EU harmonization laws, the public works law was changed and it has become possible in theory to establish places of worship other than mosques. Because although the right to worship is constitutionally protected in Turkey, when we look at the outcomes, what happens in practice, when we look at the outcomes and really what happens in practice, we see that the Alevi community, Protestant churches, or Jehovah's Witnesses are not able to acquire place of worship status for their worship places. They worship in their respective buildings, and most of the time they are tolerated. That means they are not interfered with in their worship. However, these places are not legally recognized as places of worship. This means that they are unable to take advantage of the tax benefits and public funding offered legally recognized places of worship. The reason for the denial of place of worship status for the gem houses lies in the notion that only mosques and masjid are viewed as legitimate places of worship for Muslims. There are three justifications given for this denial. The first is based on the opinion of the Presidency of Religious Affairs that Muslims worship in mosques. And the second one on the law that governs the powers of the Presidency of Religious Affairs only refers to mosques, and that a law that was adopted in 1924 on the closure of Dervish lodges would be applicable to gem houses. These reasons, however, are not convincing. The law cited in such decisions on the Presidency of Religious Affairs governs its duties and powers, and that cannot be interpreted to mean that there are no other places of worship other than mosques. Meanwhile, contrary to what is argued, Law 677 on the closure of Dervish lodges does not constitute a barrier to the recognition of gem houses as places of worship, because if gem houses were within the scope of that law, they should not be allowed to exist as they are. In the case of the Protestants and Jehovah's Witnesses, these communities report that the regulations on places of worship are formulated with the characteristics of mosques in mind and are very difficult to fulfill for them. They complain that when they apply to the local authorities for the recognition of their buildings as places of worship, they are rejected because their buildings don't comply with these regulations. Then, when they ask the municipalities to show them a plot where they can build places of worship, they are told there are no places designated that can be allocated to these groups. As a result, the right to establish place of worship means a trapped right for these communities. The state's failure to fully remain neutral in relation to the right to establish places of worship results in the recognition of a limited and selective pluralism. The officially recognized religious diversity in this context does not correspond to the religious diversity that exists in fact. Determining which actions should be regarded as manifestations of religion or belief in worship or practice, or which beliefs should be recognized as beliefs or religions, are not within the competency of the state. With respect to such issues, the reference point should be the views of the believers. And this brings us to the issue of conscientious objection to military service. Although conscientious objection is a human right protected within freedom of religion or belief, Turkey does not recognize it as a human right. And the Turkish Constitutional Reconciliation Commission has not reached an agreement regarding the recognition of this right. And 2 military courts, however, have recognized this right in 2012 with reference to Article 9 of the ECHR. However, they discriminated based on the beliefs of the applicants. The request of a Jehovah's Witness was accepted and he was acquitted, but that of a Muslim was rejected on grounds that conscientious objection has no place in Islam. Hence, the court made a theological assessment of whether there is conscientious objection to military service in Islam or not. Again, here we see the involvement of public authorities in their decision-making with theological assessments. As far as pluralism is concerned, state's responsibility presents itself at least in 2 spheres, as I said. First, ensuring that diverse religious or belief communities can exist together peacefully. And second, that belief communities can maintain their autonomous existence. It directly concerns not only the organization of the community as such, but also the effective enjoyment of the right to freedom of religion or belief by all its active members. Respect for pluralism requires that states make it possible for belief communities to maintain and develop their identities, characteristics, and practices. This means that in order to ensure plurality in society, states have to refrain from interfering in the internal affairs of belief communities. The lack of legal personality of belief communities in Turkey makes the autonomous existence of belief communities highly vulnerable. No belief community in Turkey has legal personality as such. Legal personality is an enabling right which empowers belief communities to collectively exercise their rights. Without legal personality, they cannot even sign a contract as a belief community, to rent facilities for worship purposes, or to own property.